SJC-13540, Commonwealth versus Carlos M. Rodriguez.
Okay, Attorney Shivitz.
Good morning, Your Honors. May it please the Court. Abby Shivitz here to represent the appellant, Carlos Rodriguez. So I'll get right to the heart of the problem with the Superior Court decision in this case. Looking at the circumstances of Mr. Rodriguez, he is now 70 years old. He's confined to a nursing home, which is a locked facility, with a shunt draining fluid from his brain. He has a history of severe balance problems and vertigo, and there's nothing in the record which suggests that he has a car or license or even access to Marlborough and Framingham, which are 70 miles away.
As far as the medical testimony goes, at least for the term of probation, is the record clear that he's going to stay and not get better? I mean, I think he has a dementia of something. So he has something seemingly irreversible. But is the record clear that he's not going to be able to travel to those two towns during the period of probation?
Okay. Well, the record does establish the history of medical problems that he has. And his hydrocephalus, he does not have any real cognitive issues, except he had a record of potential Parkinson's symptoms, so it's possible there's some cognitive issues there. There's nothing in the record about him having a car or a license, so that would be outside the record. And he does reside at Mission Care in Holyoke based on his status as a type 2 diabetic. So he's not allowed to leave out of his own accord. He can't just walk out of the facility and drive somewhere, and especially in this case.
Just trying to understand what that means. Is he in is he in one of these units where it's locked, or is it just mean he can't leave by himself because he's not capable of leaving by himself?
Well, I think it's twofold. He's not in any kind of nursing home, but for the safety of the residents, the floors are locked. They're keypad coded, so they can't get onto an elevator or get down to the stairwell unless they put in a keypad code, and they can't walk out the front door without being buzzed by security, and that is for the security of all the residents, and most of the residents aren't not justice involved. It's because they suffer from severe cognitive and medical issues.
That's what I'm confused. So, but his diabetes is why he's in there. Yeah,
that was why. He has a lot of health issues, and being a type 2 diabetic was how he was accepted to Mission Care. He also has high blood pressure, many medications.
If he can operate a keypad, so if he keys himself out, he can leave.
Potentially, if he were to acquire the code, he could and somehow get through the front door security and get buzzed out. He could potentially.
Well, I guess the bottom line is he allowed to leave on his own or not?
I think if he had a family member that wanted to take him out, he'd be allowed to go. And I know that the nursing home does provide residents with opportunities to go on field trips, and so. But all the residents are constantly under supervision. They just can't go out alone. They have to be with someone.
Let me ask you a broader question. Is there a legitimate government interest in enforcing a stay away from a victim of a child rape who is traumatized from age 3 to 7?
So I would say there is a legitimate government interest in enforcing. There's a stay away from the victim and the victim's family.
Right.
But that is separate from stay away from an area, from a geographic area. So there is in this case, there's no legitimate interest in enforcing a stay away from the towns of Framingham.
Let's break that down.
Okay, sure.
All right. If we look at Feliz and Roderick, and we talked about governmental interests that have to be in play in order for there to be a reasonable search.
Right.
Do you concede that a victim's state of mind or protecting a victim from having to relive this horror, as she testified to or spoke to at sentencing and clearly affected the motion judge here, is that a legitimate government interest?
I would say that these were legitimate factors at sentencing, but not a legitimate factor at the actual motion hearing, because it was incumbent upon the Commonwealth to actually present evidence.
Why not?
Why would
so we have someone who was raped by her grandfather from age 3 to 7, who says, I can't bear to stand to see the guy at sentencing. Is there a legitimate government interest in the state keeping that offender away from that victim?
I would say, well, there is a legitimate interest in that there is a valid stay away. So that would keep the defendant away from the victim. If he were to encounter her, he would have to cross the street. But in terms...
How else do you force a stay away other than the GPS?
Okay, so the GPS, in this case, as it is, because there are no legitimate exclusion zones that were ordered at sentencing, the only way this GPS will function, and in Massachusetts, it's an alert-based system. So if he were to, say, violate the no-contact order and get too close to the victim, someone would have to report it to the authorities, and then the authorities would come looking for him, and then they could go back and look at his GPS and say, oh, were you in front of this store where the victim was? And so in this case, a GPS will only serve potential post hoc investigative use by the authorities.
What about deterrence?
It will serve a certain deterrent effect.
If he can't go to Framingham, or what was the other town? I'm sorry.
Marlboro.
In Marlboro.
Yes.
Doesn't that deter him from going to the places where she can be found?
Well, certainly, the way the exclusion zone is now, he's not allowed to go there, and the device will alert because it's been configured. But the issue of exclusion zones it's a separate issue because there is no legitimate authority for the judge to have even established these exclusion zones after sentencing. Because in order to do that under Goodwin, there needs to be some kind of a material change in the defendant's circumstances, meaning a violation of probation.
In Goodwin, at sentencing, was there a stay away or no contact?
I don't specifically recall, but I would think
I think the answer is no.
there would be.
I think the answer is no in Goodwin, right?
There was, I honestly, I don't remember if there was a stay away in Goodwin.
Well, in Goodwin at sentencing, there was no stay away, but then conditions included a stay away after sentencing.
Post-sentencing, yeah.
Right, and then putting on the GPS and exclusion zones.
So then there was a third modification
Okay.
to supplement the stay away with an exclusion order.
Which implicates double jeopardy.
Yes, and it definitely implicates it here. Because,
Well, here, though, at sentencing, the judge said there's a stay away, no contact from the victim. And then post-sentencing, the judge set the terms of that stay away, no contact.
well, at sentencing, there was a stay away from the victim and the victim's family. So that's a stay away from a person who is mobile, and that's different than a stay away from a geographic area. So what happened at the hearing, after the hearing even, when the judge established the exclusion zones, the geographic exclusion zones, that was a modification of the sentence that he was not authorized to do because there was no violation of probation, and that was the double jeopardy violation. They were unlawful.
How do we know if something's a what's the legal test of something that violates Goodwin and is a modification without a violation, as opposed to something that's a clarification of the scope of the stay away order? Right. We now know the victim tends to be in Marlboro and Framingham.
Right.
And so to affect the stay away order, which is already part of the sentence, why would that be problematic under Goodwin?
Under Goodwin, it's problematic because a judge doesn't, I would argue in this case, putting in these exclusion zones, which are so punitive and really a severe increase in the change of the original conditions, that it's not a clarification, it's not a modification, it's not telling that that the
Is
judge.
it because it's punitive? Is that what it is? I'm trying to figure out the
Yeah, I
legal
think it's
test as
twofold.
opposed to just in this particular
Right.
case.
So I think it's twofold. I think that there can't be any kind of a modification that would increase the scope of the original terms unless there has been a violation of
Let me
probation.
ask you, if the judge in this case, there's a stay away, no contact from the victim, we know that, it's
Yes.
original sentencing, the person does this sentence, they come back under the Feliz motion, and suppose the the judge asked the Commonwealth, well, where does the victim live? And the Commonwealth said they live at 33 Main Street in Framingham. And the judge said, okay, pursuant to my stay away, no contact, you're excluded from 33 Main Street. Would that be a double jeopardy violation?
Yeah, I would say it would be a double jeopardy violation because it is a material change from the original conditions, and it's adding to the sentence that something that was not there originally. In this case, it's easier because it's including two huge towns, and these aren't even towns where the victim lives. It's where she visits her family. Those are extremely punitive. The scope is so huge. It doesn't make sense, and it doesn't comport with the precedent in Goodwin.
Excuse me, can you please tell us what's in the record regarding the burden on the defendant here of the exclusion from those towns? Your brief asserts that it's the only place he's ever lived, and that I think that he has trouble accessing a bank account. But could you tell us what exactly is in the record about that?
There's no evidence in the record about details about the bank account. This is just because I know Mr. Rodriguez and that this is the only town he's lived in, and he spent his life in Massachusetts in that community. But what is in the record is that the victim, and I think going even back to the trial records, the victim was from Framingham, and her grandfather lived there and took care of her, and that was the community he resided in. So that would probably be the only thing in the record regarding those factors.
Thank you.
Do you want to address the sort of more general problems? From what I gather, probation is keeping these on without a hearing, and your client, it was put on your client without a hearing and remained on your client for a certain number of months without a hearing. Do you want to address those and whether that's permissible and what the appropriate remedies are in that context?
Sure. And these were issues that were addressed in the amicus brief, and
Right. Mm-hmm.
and I'm definitely supportive of what was put forward. But as it stands right now, it is
Not only you're impacted by it, right? Your client, it remained on him without a hearing for how long?
so it was approximately 33 days from the time he got released, November 18th, 2022, to the time of the hearing, which was December 21st of 2022. So he went about 5 weeks before the hearing could be scheduled, and then after that, and at the hearing, the judge did indicate it would be a quick decision, but it actually, I think, was an additional 5 weeks. So we had about 72 days where he had this presumptively illegal and unconstitutional device, which is searching him, on until there was a final judicial decision at the end of January.
Remember, did we address this problem in either Feliz or the other case about sort of the time lag problem?
No, actually, that's what wasn't addressed, and that's why courts don't have the guidance that they require. Things are happening differently in different courts right now. And our argument is that this burden should not be on a defendant. Mr. Rodriguez is really lucky because I happen to represent him in his direct appeal and his medical parole petition, his parole hearings, and I knew years in advance that when the time came for release, we would have to deal with his GPS. But most of the defendants that CPCS is concerned with, and the reality is that these are people who are unrepresented. They don't understand Feliz. They don't know about Feliz. They would have to go out, establish their indigency in court, get assigned counsel, and then have counsel file a motion to vacate. So I would say that Mr. Rodriguez is the exception. The defendants who know that they need to go out right now and shoulder this burden are the exception, but the vast majority of defendants don't know that, and it would be much easier and more just to just have the Commonwealth bring these people into court.
Because it's probation who...
So it depends on if they're still incarcerated, it's easy for the Commonwealth to just schedule a hearing, and that's where the CPCS and the Commonwealth agree. But once the probationer is out there, it should be the burden of the Commonwealth to move to impose GPS. And then to bring the person into court, they get assigned counsel, and the judge conducts the balancing of interests.
Because we assume this is hopefully a finite problem because it really deals with the population of people.
That is...
Right, because anybody who's incarcerated before they're hooked up by probation, they should have notice and a right to be heard. And of course, going forward after Feliz, it's a sentencing issue.
That's correct. And I think there are about 600 inmates right now that were sentenced before Feliz, and there are under 350 probationers that were sentenced before Feliz that would require that hearing. So it is finite, and definitely the Commonwealth has the resources and information to be able to do this, versus these defendants who just don't know, and it's really quite unfair that they would have to shoulder the burden of a presumptively unconstitutional search. If there are no more questions, I would rest on my brief.
Okay.
Thank you very much.
Thank you. Okay, Attorney Langsam.
Good morning, Madam Chief Justice. Good morning. May it please the Court. Jessica Langsam, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. Justice Pierce correctly ruled that the Commonwealth's interest in imposing GPS monitoring on this particular defendant outweighed the intrusion on the defendant's privacy for 3 reasons. First, the Commonwealth has an interest in protecting this victim and in protecting the public by strengthening enforcement of the stay away, no contact order, which Justice Pierce had ordered at sentencing in 2018. Second, GPS monitoring supports the Commonwealth's interest in enforcing the exclusion zone, which Justice Pierce added in his order denying the defendant's Feliz motion. And third, GPS monitoring supports the Commonwealth's interest in deterring and investigating future sex offenses where this defendant has been classified as a level 2 sex offender by SORB, which means that he poses some degree or some risk of reoffending and a moderate degree of danger to the public.
Feliz calls for the individualized assessment, correct?
Yes, Your Honor.
And I get your arguments about the governmental interest, especially with respect to the victim's peace of mind.
Yes, Your Honor.
But what I don't get is, as we individualize this, how this makes sense for someone who is essentially bound to a medical facility.
How having a GPS...
Because of the person's medical condition, and how basically we're going to be putting a GPS monitor on someone who's confined to a medical facility because of his health issues.
Yes, Your Honor. And
how does that make any sense?
Well, and as the bench has just elicited, I mean, health is a fluctuating factor. It's not a static factor. It's a dynamic factor. And while this individual is there, has substantial medical needs, was originally placed there because of his diabetes, that could change. And as counsel just represented to the court, he's not prohibited from leaving there, even if it might be challenging for him to leave by himself. And
What is your understanding of the restrictions in place for him? Because he's not in one of these memory units where you're not allowed out, but he's, I don't understand exactly, what's the record show about his ability to leave? If he calls up a buddy to ask him out, he can leave, is that right?
yes, he can, Your Honor. So the evidence, and just to point out, there was no testimonial evidence. Justice Pierce held a non-evidentiary hearing at which the court considered documentations and affidavit submitted by defense counsel and the representations of the Commonwealth with respect to the SORB classification. But and what Justice Pierce clarified is exactly the question Your Honor, Justice Kaffer just asked, which is there any legal prohibition on him leaving? No, there's not. So he could leave. There is an affidavit from an individual at Mission Care that was part of, I believe, defense counsel's supplemental affidavit that's in Appendix 2, indicating, as she just as my sister represented to you, that he is on a floor that requires a keypad to get into the elevator. And when Justice Pierce asked, well, if he got the keypad code number and potentially got out, and he could make it past the front desk, and then my sister represented that presumably someone in the institution might call the police, but there's no legal requirement keeping him there.
He can have a visitor come who doesn't understand any of this and take him out driving, right? That's not prohibited. I mean, obviously the visitor has to check into this facility and everything else, but somebody can come visit him and take him for a drive, right?
Yes, Your Honor.
How can he be arrested if he's not detained?
I beg your pardon, Your Honor?
You said that someone at the front desk would call the police.
Someone at the front desk could call the police.
For what?
This is when Justice Pierce was asking my sister at the Feliz hearing whether or not there was any legal prohibition on him leaving to alert probation if he's leaving. So he's not required under the terms of his probation to stay at this facility, but if he's moving, that I think that would set off an alert, and so probation would be informed. So that probation would be informed. That's what, not that he would be arrested for leaving the facility.
Are the exclusion zones too broad?
Thank you, Your Honor. At the time that Justice Pierce entered this order, certainly Section 47 was the law, sentenced the defendant. It was Section 47, and Justice Pierce could be confident that this defendant would be on GPS monitoring. And as the court's familiar with the serious crime that this defendant committed against a child, that was part of the sentence that the judge crafted, not including the exclusion zones. And so then when the law changes and then the defendant is a SORB level 2, Justice Pierce added the exclusion zones to give effect to what his intent was at the time that he crafted this sentence.
Can you respond to the contention in the reply brief that Justice Pierce essentially treated this as a resentencing hearing following Feliz?
Yes, Your Honor, and I would argue that it's not a resentencing. There was no violation of probation, but there was a material change in circumstances, and that's the defendant's designation by SORB, who had preliminarily designated him as a level 3 offender, and then after a hearing in September of 2022, showed that he was a level 2 offender. So level 2 means that, as the court is aware, information about the defendant, his crimes, his photograph, in fact, 2 photographs of him, and his address are available to the public because that's the level of danger that he presents.
So do you if you didn't have the SORB level 2, if this is a quite different case and you didn't have the SORB level 2 classification, would you agree it was improper because there was no material change in circumstances to impose an exclusion zone where previously there was no exclusion zone?
Well, Your Honor, the SORB level 2 wasn't the only change, and it was the issuance of Feliz is also a change. So the law has changed, and
that decision was more protective of defendants and said that defendants couldn't just be willy-nilly given GPS and needed to have an individualized assessment, right? So it's a little strange to say that that decision is a change in circumstances that warrants imposing not only GPS but also exclusion zones on top of GPS.
Well, right, Your Honor, but the material change in circumstances is the defendants, so taking out the SORB portion, and I would point to, and Your Honor, Chief Justice, I want to get back to your question, but just the case of Morales, which is cited in the Commonwealth's brief, and that's a case that sort of addresses what your question was, Your Honor, is that in that case, and that was Justice Katzmann wrote that opinion where the defendant was SDP, and that was held to be a material change in circumstances. And when the original sentencing judge had imposed the sentence, obviously that was unknown, so that was held to be a proper, that was a new condition. A new condition was imposed that this individual not reside where there are minors, and that was held to be proper in light of this.
So is your position that there, for all of these Feliz defendants, we'll call them the Feliz defendants, the people affected by Feliz, for all of those defendants, there is a material change in circumstances, so judges, when they're resentencing these defendants, can give new exclusion zones to all of them? If the judge thinks that, to vindicate certain Commonwealth interests that are legitimate, that an exclusion zone would be good.
Well, Your Honor, it cannot be, and this is what I tried to point out in the brief, in reading Goodwin in light of Feliz and Roderick, it cannot be that a Superior Court judge who presided over the trial, imposed the sentence, heard the victim impact sentences, the person who's most familiar with this case, crafted a sentence, and then is trying to retain the integrity of the sentence that that judge imposed at the time, that the judge can't make appropriate adjustments in order to effectuate that sentence.
But there's a 60-day limit.
Well, that's, Your Honor, with respect to a Rule 29, and we're not talking, and that's not a rule. This is not a revise and revoke.
What is the basis for your principle that a judge who a while ago heard the trial and did the sentencing, when he's having a hearing to do an individualized assessment about whether GPS was even appropriate for this guy, can impose additional conditions?
Well, to the extent the court concludes that there's no material change, I would look to the inherent power of the Superior Court, and this is a different circumstance. So where where imposing GPS on an individual, even if there were no exclusion zones, here, this is a defendant who is in a different position than the defendants in Feliz and Roderick. And in Feliz, you had a no geographic victim. You had an individual who possessed and distributed child pornography, and he was a level 1 sex offender. In Roderick, you have an individual who raped someone. The victim had been living in a tent in Connecticut, or no one was quite sure where she was. He was a level 2 sex offender, but the Commonwealth couldn't show at the time of the Feliz hearing where this individual was. Here, we have an individual who's a level 2 sex offender who is, per the probation officer, and as Justice Pierce found at the hearing, is often in Framingham and Marlborough. And so in order to effectuate that, that's why Justice Pierce added the exclusionary zones, which, to your point, Your Honor, are broad. But I would submit to the court for the other reasons that even if somehow the addition of the exclusion zones was too broad, and though under Goodwin, the modifications, and in contrast to what my sister said, the court can make modifications so long as they are not, quote, so punitive as to significantly increase the severity of the original probationary term. And where the defendant was already ordered to stay away and have no contact with the victim or her family, and that's where the family lives, and the defendant knows that because he's part of the family, it really cannot be said that these two towns, though it is a broad geographic area, was not so punitive as to significantly increase the severity of the original conditions. But even without, but just to jump around a little, even without the exclusionary zones, I would submit that in contrast to the cases of Feliz and Roderick, that it might have been that Justice Pierce believed that in light of Roderick, that an exclusionary zone was needed in order to justify the GPS, but I would submit that it wasn't here.
Well, if the exclusionary zone is needed to justify the GPS under Feliz, doesn't that suggest that the exclusionary zone has significant meaning?
It does, Your Honor, but looking at this in the totality of the circumstances. So that's just with respect to the Commonwealth's interest in strengthening enforcement of the stay away, no contact, the exclusion zone, just that one piece. And then, as the court has recognized in Roderick with respect to deterrence and investigation, SORB level 2, where this is an individual who the defendant presented a lot of information at the hearing, and Justice Pierce included it all in the order denying the Feliz motion of this low risk of recidivism. But that's not what SORB said. And SORB held a hearing, and there was clear and convincing evidence that he's a level 2. So that fills in that piece. So, but it's only with respect to the one piece when this court is considering all of the different factors under the totality test.
Can you turn to the question about what should happen for all the Feliz defendants? And could you particularly address the question, I read Feliz as saying the government cannot affix a GPS without doing an individualized determination with respect to that defendant.
Yes,
so
Your
why
Honor.
doesn't that just set the rule? We don't need some fancy sort of set of like who files a motion. The parties are fighting over like we should have to file a motion. We should have to file a motion. Isn't it just clear from Feliz like you have to have a hearing before you can add the GPS?
Well, yes, Your Honor, and so it's presumptively unconstitutional. However, for those less than, I think as amicus said, there were 356 individuals who are currently on a Section 47 GPS, and they don't know how many of them have already had the Feliz hearing. I spoke with legal counsel for the probation service, and they couldn't come up with that number. But removal of the GPS without having this individualized determination would create a public safety issue. And these, to respectfully remind the court, these are individuals who have been convicted of a crime. And so—
But isn't that problem the Commonwealth's? I get it. It is a public safety problem, but doesn't that mean you have to go out and do these hearings immediately?
Well, and yes, Your Honor.
And the probation can't just sort of let this go on without those hearings, right? I mean, I get it's a practical problem and a real one, but isn't your solution in your brief is they get to it when they get to it, but isn't that inconsistent with their constitutional rights?
Well, Your Honor, it would seem that for this discrete number of individuals, perhaps probation could come up with a list of all of these individuals who are currently on this.
Do we have to order emergency hearings on these things, or I just don't know how it's consistent with what we said. If this Feliz is issued when?
In 2019, Your Honor.
And we're in 2024,
Yes.
and there's still people without these
There were
hearings?
unknown number of people who were.
That's not good, right?
Agreed. And so for those defendants who are still incarcerated, I mean, it's the defendant who knows his date of release. Certainly, they should have a hearing
But
before.
as we said in Roderick, really, the analog here is a search warrant, right? Because a police hearing is really a search warrant.
Yes, Your Honor.
And you don't get to search the house and then get a warrant afterwards.
That's right. So it's justifying the warrantless search.
Right.
So certainly, the hearings need to take place as quickly as possible. Which of the broader Commonwealth, which entity is in the best position to do that? The probation service knows which individuals are operating under a GPS under Section 47.
So, again, what does the last two paragraphs of our decision say about this? Yeah, given we have a constitutional violation in some cases that's 4 years old or 5 years old.
That's correct, Your Honor. I don't know. So not only do we not know the number of people who have a Section 47 GPS post-Feliz, we also don't know how long they've had it. But this information can be ascertained, can be determined by the probation department. And once the information is determined, the Commonwealth certainly wants to have these hearings. In fact, it might be that the Commonwealth does not have an interest in retaining the GPS with respect to everyone. But for those individuals that the Commonwealth does, certainly a hearing needs to be scheduled expeditiously, and it could be, as it was in this case, a non-evidentiary hearing. And if there are no further questions, I would rest on my brief.